Hey folks, it's a very good chance that your trust is not protecting you, your spouse, and your loved ones the way you think it may. I've been teaching free educational workshops in the community for nearly 20 years, and I've reviewed thousands of trusts for clients and new clients. And from my experience, they have a very false sense of security around the trust that they created many years ago. It's what I refer to as a garden variety trust. It might be a trust that's designed to avoid probate court, and it's not even going to avoid probate because your assets were never transferred or funded into your trust. Folks, I call it the metaphorical four-headed monster. A proper asset protection trust protect you from probate court, the tax man, financial creditors and predators, and maybe that $20,000 per month private pay nursing home. Number one. Folks, your trust will only avoid probate court if your assets were legally transferred to the trust. So if you are Bill and Mary and you created your trust, your assets, your home, your bank accounts, your investment accounts, etc., should have been legally funded and transferred to your trust from your name as individuals to your name as trustees of your trust. Transfer the asset from Bill and Mary to Bill and Mary as trustees of your trust. People die, but trusts do not, folks. If all your treasures or your assets are not transferred to your trust, or what I like to call your treasure chest, it's not even going to avoid probate court. Number two, folks, if you live in the Commonwealth of Massachusetts, where our Elder Law Care Center is, we have a thing called the estate death tax. You have to make sure that you have the proper tax planning language in your revocable trust designed to reduce or avoid the estate tax to the greatest degree possible. If you do not have the proper tax planning in your trust, your spouse and children may be paying money to the taxing authority. Number three, if you feel you worked hard for what you have today, raise your hand. We worked very hard over the last 5 or 6 decades to accumulate what we have here today, and we want to leave our children better than a gift. We want to leave them a protected gift. From my experience, 90% of the trusts that I review for new clients do not have any asset protection in there whatsoever. So if you want to protect your children from what I call times of turmoil, lawsuit, automobile accident, a divorce, in-laws turning into outlaws, you need to have the proper asset protection language in your trust. And then, folks, the fourth-headed monster is a question you want to ask yourselves. If either you or your spouse became completely incapacitated, how would you pay for that $20,000 per month private paid nursing home? Most folks do not have $500,000 or more in their family piggy bank to pay for that private pay nursing home. But if you have equity in your home is at risk, because Medicaid will say your home, valued at even more than $1 million, is a non-countable asset for Medicaid eligibility, but that does not protect your home. Important to know that. You pass away and your home ends up in probate court, Medicaid is permitted to put a lien on your home. They're permitted to be reimbursed dollar for what they paid in for your care. Folks, if you'd like to learn more, click the link in this YouTube video here, and I will teach you more, because I created a program on the top estate planning mistakes that people make, and this will help you. Also, click the subscribe button and the notification bell, because we will continue to keep you updated on other important elder law matters. Thanks for joining us here today at elderlawcare.com.